Professor Dane was trained at Yale and at Yale Law School and clerked for Supreme Court Justice William Brennan, among others. And he taught for 9 years at Yale Law School. He's written landmark articles on choice of law, religion and law, Jewish jurisprudence, legal pluralism, and jurisdiction, and recently has written on same-sex marriage. He was also recently a Tikva Fellow at NYU Law School, and we're just getting his PowerPoint up.
So like everyone else, like all the other speakers, I'm delighted to be here, and I want to thank the Aspen Center, just another plug for them, not only for organizing this conference, but for bringing all of us to this wonderful venue. So this talk is partly about understanding religious tribunals, like a Beit Din, and trying to add some depth to how we conceptualize religious tribunals, what they are, what they mean, and also how we justify them. You know, why should religious tribunals play any role in the modern secular state? Unlike some of the other talks, I'm going to get relatively theoretical. So just bear that in mind. Most of the talk will be narrow in one sense. It'll focus on the contemporary scene, but broad in another sense, in that I'm going to talk, at least what I'm going to say is going to be relevant to all sorts of religious tribunals, Jewish, Muslim, Christian. At the end of the talk, though, if we have time, I'm going to reverse things a bit. So I'm going to focus in on the Jewish context, but at the same time zoom out and try in the last 5 minutes or so to cover several thousand years of Jewish history, which is an impossible task, but I'm at least going to try to outline a couple of things that might be relevant to the larger inquiry. You'll also notice that there's a certain sort of dialectical quality, or to use a less fancy term, a sort of zigzag quality to what I'm going to be talking about. So I'm going to go off in one direction and then suggest that was all wrong. That is, what I said myself was all wrong, and then do that again. And in the process, maybe we'll get some wisdom. So if along the way you end up disagreeing with something I've said, chances are that in the next part of the talk I will myself disagree with it. So be relieved about that. So fasten your seatbelt and let's get going. The talk is going to have 3 parts. The first will draw a contrast between what I call private ordering and legal pluralism. And I'll explain that in a bit more depth. The second part will then take that contrast and suggest that it's not nearly as stark as one might suppose. And then the third part, as I just suggested, will zoom in on the Jewish context and zoom out historically. So let's begin with where some of the other speakers have begun, which is that religious tribunals, in this case a Muslim court, a Jewish Beit Din, various Christian, often mediation services, but sometimes more than that. Various sorts of religious tribunals have become increasingly prominent in recent years. They adjudicate religiously sensitive questions like marriage and so on, but they also, and we just heard a whole talk about the possibility of this, they also adjudicate commercial disputes, other sorts of disputes that parties bring before them. But these religious tribunals have also become increasingly controversial. And Michael Helfand in his talk yesterday was talking about that. Much of the controversy, and in fact the most specific attack, has of course been on Muslim courts. And any effort to defer to Islamic law in secular courts. And as Michael quite rightly suggested, a lot of that opposition has arisen from really nothing more than religious prejudice, xenophobia, identity politics. I mean, sort of the culture, the sort of specific anti-Islamic culture war that we've seen in recent years. It has been swept along by fear-mongering, misunderstanding, and lies. So again, as Michael talked about yesterday when he was introducing us to some of the anti-Sharia laws, version 1.0, right? That first generation of statutes specifically picked out so-called Sharia law, which, by the way, is a total misnomer, right? Anyone who's a serious Muslim would never use the term Sharia law. I mean, for all sorts of technical reasons, it's not Sharia law. So, so when people start talking about that by itself is a problem. But in any event, these statutes picked out Sharia law, and by common agreement and some court decisions, they were clearly unconstitutional. But again, as Michael said yesterday, the debate has refined itself. It has simultaneously become more nuanced, to some extent more, quote, reasonable, but also at the same time more threatening to a wide variety of efforts to resort to religious decision-making by persons of all faiths in the United States. So I'm going to put up a version of really the same statute that Michael quoted yesterday, which he referred to as sort of anti-Sharia 2.0. But as you see, it's not just anti-Sharia. He cited the Kansas version. This is the Oklahoma version, which is really very similar. It's a 2013 statute on the prohibition on use of foreign law. And they define foreign law to mean any law, legal code, system of jurisdiction, right? So you know what they're talking about, but at least the sweep of the law is much more general than that. So that's what foreign law is, and then there's this specific provision, and there are actually several specific provisions. I'm going to focus on this one. Any court, arbitration, tribunal, or administrative agency ruling a decision shall violate the public policy of the state and be void and unenforceable if it bases its rulings or decisions in the matter at issue in whole or in part on foreign law as defined in the previous section, right? So not just the law of foreign countries, any system. Any foreign law that would not grant the parties affected by the ruling or decision the same fundamental liberties, rights, and privileges granted under the United States and Oklahoma constitutions, including but not limited to due process, right? So our civil conception of due process, if it's not enforced by these courts, makes their decisions unenforceable and void. Freedom of religion, right? So a religious court has to grant freedom of, it's an interesting idea. Speech, press, privacy, marriage, right? Go ahead.
Well, based on the previous topic,
yeah.
If a based in use of shara, which isn't really applying a foreign law, but actually applying compromise, would that then be like a loophole for this statute?
Maybe, I don't know. Except to the extent that that in itself is a Jewish law concept, and also to the extent that it might be going from the frying pan into the fire, right? Because of this due process question, right? That is to say, if you're basing yourself on, quote, common sense, are you really adjudicating in a way that's consistent with the state's standard of due process? I don't know what the answer to that is. Now, the statute does have its own loopholes because they didn't want to be totally unreasonable, and more cynically, as Michael pointed out, they, and I think quite rightly, they were picking off various forms of objection, right? So when the corporations objected, they said, well, it doesn't apply to corporations. It also doesn't apply in a way that's going to restrict religious rights. Interesting. And another interesting thing is that it doesn't apply to traditionally recognized ecclesiastical adjudications of certain sorts of specific matters that our courts have traditionally always left to ecclesiastical adjudication. So, for example, you might have heard of a recent adjudication in the United Methodist Church about a particular minister who performed the same-sex wedding ceremony for his son. A lower court in the Methodist judicial system actually expelled him from ministry. He appealed. He was upheld on appeal. The point is that that's the sort of question that our civil courts will not get involved in, will always defer to religious tribunals, and the Oklahoma statute recognizes that, even though this Methodist court is applying, quote, foreign law. So there are these various loopholes, these various sorts of restrictions. But even so, there's a real limit, at least an effort to create a limit on the reach of religious tribunals, and a threat to the possibility of folks going to religious tribunals to adjudicate all manner of issues, both traditionally religious issues, but also others. So a typical response to such statutes and other attacks on the legitimacy of religious tribunals, and it's a response that was very much in the spirit of some of the other presentations, a typical response is to compare those sorts of religious tribunals, or that is to say, to lump them in as simply another form of alternative dispute resolution, right? ADR, right? That's the name of this panel, right? ADR something or other, right? So simply to think of, so a typical response is to say, you know, we send things to alternative dispute resolution all the time. There's the American Arbitration Association, there are all of these other groups. What's the big deal if it's a Sharia court or a Jewish court or a Christian conciliation service? Alternative dispute resolution is best thought of as a form of what's sometimes called a private ordering, right? So the notion here is that religious tribunals can be explained and defended as private ordering. They simply reflect the consensual agreement of the parties, right? It's a contract. These parties are exercising their personal freedom of contract to take their disputes outside the court system and resolve them through alternative means, right? So the defense of these religious courts is basically to say it's not such a big deal. Right, it's not such a big deal. They might be religious, but apart from that, they really are just forms of private ordering. They're expressions of contractual consent. They're forms of arbitration. This notion of private ordering and alternative dispute resolution, however, is not the only, and I want to suggest it might not be the best way to think about religious tribunals. Or for that matter, not just religious tribunals, but other types of non-state tribunals. There's a very different approach, which I want to put on the table, a very different approach that would understand and justify such tribunals as expressions of what's often called legal pluralism. Right? I love that picture, right? Because it's, you know, there's the church, there's the unfinished Capitol building, right? Legal pluralism. The basic claim of legal pluralism, and this is from an article that I co-wrote recently, the basic claim of legal pluralism is that law and juridical dignity are not the sole province of the state. Other legal orders, right? Other legal orders of all sorts exhibit many of the attributes of what we loosely call sovereignty. Right? So there's a tendency to associate the idea of sovereignty with the state, but what the legal pluralist argues is that the world of sovereignty is much bigger than just states and countries and traditional forms of government. that we can attach this word sovereignty to a whole bunch of other types of legal systems, decision-making systems, forms of authority. Now, you might wonder about that title, Saving Rutgers-Camden, and how legal pluralism is relevant to Saving Rutgers-Camden. It's a long story. It's a very long story, and I'm not going to get into it now. But believe me, it is relevant. So, put crudely, right, and this is very crudely, the claim of legal pluralism is that religious and certain other tribunals of distinct normative communities, that's another sort of fancy way of saying, people who share certain ideas, certain norms, certain traditions, those tribunals of distinct normative communities are not just expressions of private contracts, they're at least roughly analogous to, say, foreign countries or foreign states. So in this view, when Oklahoma looks out at the world of other sovereigns, right, which it does, right? It's not so silly as to imagine it's the only sovereign in the world, right? Actually, I shouldn't say that. But, I wouldn't say too much about Oklahoma. Anyway, but when Oklahoma looks out at the world of other sovereigns, in this legal pluralist view, it certainly sees Texas, right? Texas is another sovereign. It certainly sees France, maybe. Again, one needs to be careful here. But in the legal pluralist view, in addition to seeing Texas and France, it sees the Jewish world or aspects of it or dimensions of it as a distinct normative community that has its own sovereign status, and it sees the Islamic world as well. Now, of course, that metaphor is a gross oversimplification. It has all sorts of problems, but it strikes me as at least as good a metaphor, and in some ways a better metaphor than the one of private ordering. Now, legal pluralism is a powerful idea. It helps explain our legal traditions' respect for free exercise of religion. It helps explain certain aspects of the Establishment Clause. The Oklahoma statute I just quoted actually gives a small nod to legal pluralism in its recognition of the distinct role of ecclesiastical tribunals. Right? It doesn't want religious courts, but it's okay with ecclesiastical tribunals, not quite recognizing that they're really very similar sorts of phenomena. So it's a powerful idea, but it's also both controversial and unsettling. It's even threatening in some ways. By definition, it challenges the state's pretensions, and by state I don't just mean a state like as in Oklahoma. I mean any sort of traditional modern government. So France is a state, right, as well. It challenges the state's pretensions to absolute sovereignty. It's this very powerful, threatening idea. But in addition, all legal systems, right, all legal systems, whether sovereign states or religious legal systems themselves, have a certain solipsistic dimension to them. And by solipsism, I simply mean this sort of failure to recognize the dignity, the sovereignty of other legal systems. And legal pluralism directly confronts that solipsism. In a sense, in fact, the members of the Oklahoma legislature, whether or not they knew it, actually had legal pluralism very much in their sights, right? In one sense, they were xenophobic and culture warring and all of that bad stuff. But in another sense, they knew what they were doing, right? They had legal pluralism, this notion of alternative sovereignties, very much in their sights when they passed the statute I've been discussing here. So in the light of that, it's very easy to understand the temptation to sort of forget legal pluralism and just go back to this model of private ordering. It's not a big deal, it's just these contracts, it's all a matter of consent. And that would be sort of okay. It would still mean that that religious folk would, in a sense, be sort of putting on two faces, right? They would be talking to the state as if it's merely a private contract, while recognizing in their own heads that it's much more than that. But even apart from that, in fact, private ordering itself, alternative dispute resolution itself, has its difficulties. Alternative dispute resolution and arbitration are themselves controversial, not for the same reason as legal pluralism, for different reasons, but they're themselves controversial. Conceived as an expression of private ordering, ADR has been accused of compromising public values, right? Private ordering, it's been accused of compromising private values in at least three senses. First, shifting important, and again, prior talks have alluded to this, shifting important disputes from courts to arbitrators deprives the courts of their distinct role in debating and articulating our collective ideas about right and wrong. In fact, arbitration in that sense is simply one example of a much larger tendency, which some folks applaud, but lots of other folks attack, a much larger tendency to opt out of the formal machinery of the courts, whether by ADR or by settlement or mediation or otherwise, a trend that Owen Fiss, a scholar at Yale, famously challenged many years ago, actually 30 years ago now, in his article Against Settlement, right? And he was, to some extent, going against the grain. Who could be against settlement? But he was suggesting that there's something ultimately corrosive about this notion of settlement. And in fact, our legal tradition, though at the moment it's in a phase when it is very supportive of arbitration, has actually gone through various pendulum swings on that very idea. And there's a long tradition in our own civil legal systems of active opposition to arbitration precisely for these reasons. Second, the substance of alternative dispute resolution can violate those collective values that we have articulated as a society. In fact, if we look at it in this light, the Oklahoma legislature made sort of perfect sense when it said we want to keep these tribunals from violating the fundamental rights that we think are important. These are public values that they insisted these private tribunals respect. Third, arbitration is not necessarily the crackerjack alternative to ordinary litigation that it's cracked up to be. Disparities in power can get amplified and decisions can be arbitrary and uninformed. Indeed, as a matter of sheer etymology, that word arbitration, which is taken from Roman law, is by definition, judgment by an arbitrary judge. Now, of course, etymology is always a cheap shot, right? It's a rhetorical make-weight. I don't want to make too much of it. But on the other hand, just keep that in mind, right? An arbitrator is by definition an arbitrary judge. So legal pluralism, right? That other idea that I've been introducing, legal pluralism has a response to these concerns over public values, though it is not one that the Oklahoma legislatures would probably want to hear. To a legal pluralist, deferring in some cases to religious tribunals does not displace public values in favor of merely private arrangements. It's not a distinction between public and private. Rather, it recognizes a different public realm, grounded in a different tradition, grounded in different forms of authority, perhaps even different public values. Now, interestingly, this inadequacy of the private ordering model isn't limited to religious tribunals. A similar issue comes up when people try to think through, for example, international commercial arbitration, which is one important form of commercial arbitration. Here's what one author said quite a few years ago. Said the strongest argument for alternative dispute resolution advocates in the ordinary case, right, as we saw in the previous a presentation, a typical argument for ADR, for arbitration, is cost, right? And what Gilbert Verbit pointed out is that for international commercial parties, the point is not simply cost, because unlike parties whose dispute exists within a particular domestic jurisdiction, parties who fall into these sort of international commercial disputes don't have a court that they could go to that would be competent to express what they want to express, regardless of cost. Right? It's not simply a matter of cost, it's a matter of trying to capture what it is that they mean by an international, a genuinely international agreement. And in fact, the idea of the law merchant, right? The idea of the law merchant was a traditional expression of that. It wasn't seen simply as arbitration, it was seen as a system of law that merchants created that was an alternative to the system that was created by states. So what I've suggested is that this private ordering model has real weaknesses, and there's some strength to the idea of legal pluralism. On the other hand, legal pluralism, as I've also emphasized, is a very frightening idea. It's a very threatening idea. You can understand, it's sort of easier to understand why Oklahoma would be dead set against it. So we're in a bit of a bind. We're in a bit of a bind, which brings me to part 2 of the presentation. And I might not get to part 3, but that's okay, because part 3 is sort of self-standing, called double coding. And again, it's sort of a fancy term. It was actually invented by postmodern architects and literary critics. So think Venturi, for example, right? Complexity and contradiction in architecture. So this notion of double coding, the way I use it, it's best captured by several metaphors. And one metaphor for this notion of double coding is this famous optical illusion. What do people see here? Two faces. Hmm? Right, so who at this very instant sees a goblet? All right, who at this very instant sees two faces? All right, so what's interesting about this optical illusion, and I'm sure you've seen similar ones, is that it's actually both a goblet and two faces, but we can never see both at the same time, or at least I think there are very few people who can actually literally see both images at the same time. It's either one or the other, and yet it's both. And yet it's both, right? So that's one metaphor. It's one metaphor for what I mean by double coding. Another metaphor is the image of the tree, right? There's the stuff that we see above the ground, but we know that there's a lot of deeper meaning without which the stuff above the ground really can't live. And then a third metaphor is the old stereoscopic image. Those are actually two slightly different angles on the same scene. And if you have one of these stereoscopic doohickeys, you can actually bring them together into a 3D image. And the point here, right, the point here is that on the one hand, a 3D image is possible, right? You can combine, you can reconcile these two images. On the other hand, you couldn't reconcile the two images unless they were separate to begin with, right? So it's sort of the paradox of this sort of 3D technology, and this also goes for modern 3D movies, right? If you've seen the movie Gravity, right? The paradox there is that the only way for the 3D-ness to pop out, for the full depth to pop out, is to have the two distinct images to begin with. So those are some metaphors. And what I want to suggest is that on the one hand, there's a real difference between private ordering and the public realm. There's a real difference between a private ordering and what I've called legal pluralism. But on the other hand, we can understand private ordering and legal pluralism as complementary formulations, to some extent as loose translations one of the other. And it's important in thinking about a phenomenon like religious tribunals to be able to appreciate both those aspects of it, and for that matter to make use of both those dimensions when we think about it, when we justify it, when we argue about it, when we try to work out the full implications of it. So as I said, I'm not going to get to part 3, which was this 3,000-year survey of Jewish history. If I like, I can. Oh, then I'll. I have permission. Oh, then I'll just do this as quickly as I possibly can. So part 3. We have this. So what do we mean by Jewish law, right? What do we mean by the sort of Jewish sovereign system that I've talked about? I've talked about Jewish sovereign system is Muslim, Christian. What do we actually mean by that? I think most of us have a sort of conception in mind, right? What we think we know what Jewish law is. We think we know what Jewish legal authority is, Jewish governance is. It's a system of law that's been around for several thousand years. It's based partly on the written law in the Torah. It's based partly on the oral law, Talmudic, rabbinic tradition, which is both a commentary but also a supplement to the written law. It's this synthesis of the two. It is distinctively religious, right? It's distinctively religious. Some very smart historians suggest that a lot of this picture, forgive me for saying this in this venue, but some very smart historians suggest that a lot of this picture is, at the very least, very partial. I'm just going to, again, go through this as quickly as I can. Wonderful book by an old friend of mine, Michael Satlow, How the Bible Became Holy. And here in sort of 2 sentences is his thesis. What we think of as the Bible, right? The written part of our legal canon, was originally a set of scrolls that were in their reach. I forget exactly when they were written, but in their reach were very much limited to a small elite community of scribes. They were not widely known, not widely disseminated until relatively late in the process. They became holy, right? They took on the status they do now, largely, Sattler argues, as a response to Greek culture, right? The Greeks really valorized written texts and the importance of written texts. And at that point, the Jews sort of went into their closets and said, well, golly gee, we have our written texts too. And they're pretty good. And Sattler's argument is that for all that period until sort of the rabbinic period, Jewish Israelite legal decision-making was not distinctively religious. It was the product of traditional local or national authorities, and really bore, and that these scrolls that had laws in them weren't even thought of as binding legal authority. They were sort of the exercises of these scribes, the utopian visions of these scribes. Again, you can take it or leave it, but that's the view of a really superb historian. So then the rabbis came along, and the way Sattler tells the story, you had the Pharisees, who in some ways were the traditional supporters of that older system of non-written law, right? And I'm sorry, right, did I say Pharisees? Right, you had the Pharisees, then you had the Sadducees, who were the brand new sort of revolutionary Greek-influenced folks who said written texts are important. And what finally came out was the sort of grand compromise, where the written text was important, but it was interpreted through the prism of tradition. So the Judaism we have is not the victory of the Pharisees over the Sadducees, which is how we often think of it. It's really the integration of the two. So then we get the Mishnah and the Talmud, and another friend of mine, Talia Fishman, sort of carries the story forward, and she says the Talmud wasn't understood as really central legal authority for the first 1,000 years or so, that it really only took on that status in the High Middle Ages. It's not to say it wasn't respected, not to say it wasn't read, but that a lot of decision-making, again, was based on local traditions, local sources, that this concept we have of the Talmud being sort of the core document is itself fairly new. So that brings us to the High Middle Ages. Then we have other folks, including a much older historian, Sola Baron, and a more recent one, David Bialy, whose essential argument is that through much of the Middle Ages, you had Jewish self-governing communities within the context of Christian states, but a lot of their governance was by lay people, not by rabbis. A lot of their governance was not through what we would think of as the sort of strict halakhic system, both with respect to public governance and also the resolution of private disputes. And in fact, yet another recent book suggests that it's only with the collapse of those self-governing communities and the rise of the modern state that Jews began to separate out the religious aspect and put it at the center of their identity. And in fact, while you might think some of this is fairly radical, as again the previous presentation suggested, they're quite conventional sources in Jewish law that are consistent with this idea. So just like civil law has had controversies over the scope of arbitration and the permissibility of arbitration, Jewish law has had the same controversies for similar reasons, for very, very similar reasons. The sort of difference between public values and private dispute resolution. So who was it who said Jews like to argue, right? So the Talmud is full of arguments. So Rabbi Eliezer says it's forbidden to arbitrate in a settlement. He who arbitrates offends. Whoever praises such an arbitrator despises the law, right? Sounds like Owen Fiss, right? And yet the more prevalent view, right? The more prevalent view is that settlement or arbitration is a meritorious act because it's the way to reconcile truth and peace. It's the way to reconcile justice and charity. So what's the lesson of all this? And here it seems to me there's a sort of small lesson and a large lesson. The small lesson is that while I've drawn a contrast between private ordering and legal pluralism, in fact, private ordering is often embedded within traditional legal systems. It's very much at the heart of them. These traditional legal systems themselves think of private ordering as a value. And you can think of that in historic terms, or you can think of it in more textual, official terms. And what's true for Judaism is true in its own way for Islam, certainly true for Christianity. Right? I mean, you know, the whole concept of what it means to have, quote, religious law in the Christian context is makes the Jewish case seem easy, right? So this contrast between private ordering and legal pluralism turns out to some extent fail to recognize issues even within religious legal systems. But so that's the small lesson. The larger lesson is that when Oklahoma looks out and it sees France and Texas and Jewish law and Islamic law, one of the pieces of that story is that these other legal systems themselves are in conversation with each other and with the state and with the larger culture. They're not just sort of static things that get recognized out there. So if you believe Satlow, it was only with the collapse of Israelite self-governance that a more religious and text-based concept of Jewish law arose in the first place. And if you believe folks like Bialy, and it was it was only with the collapse of the older system of medieval legal pluralism and the rise of the modern state that we began to really think of Jewish law as being this sort of distinctively religious phenomenon. So when Oklahoma looks out and when Jewish law looks back, there's actually much more of a conversation than one might suppose from the simpler model that I was suggesting earlier in the talk. So what are the policy implications of that? I have no idea, and I will leave that for further conversation. Thank you.
Thank you very much.